Good evening. Welcome to the Veterans Voice. This is Amanda Manier. I am your host this evening. I'm a veteran advocate and the managing attorney at the Veterans Law Group. And this show is all about highlighting veterans, talking about some of the news that are happening in the world of veterans, some legally, some just socially. Periodically, we'll have a guest on that is helping veterans in some way. But one of my favorite things to do are shows like this, where we are taking your calls live this evening, doing a little bit of education on kind of what's going on or what we have learned over 25 plus years of representing veterans before the VA and pursuing their disability benefits. And, we can certainly talk about the letter of the law, but I'm also going to talk quite a bit about our experience and what works and what doesn't work. It's a conversation I have a lot of times with clients where they might look up a particular statute or regulation or something that the VA is quote unquote supposed to be doing, and yet we're not seeing them doing it. And what is it that we can do to either get the VA to do what they're supposed to do, or ultimately, I know most of our clients, they're just frustrated with the process of dealing with the VA. They might be struggling to support and take care of their families, or dealing with a health issue related to their time in service. And they're looking for somebody who can just kind of take it over and get them where they need to get in the fastest way possible. So I do like to talk a little bit about that on these evenings. Again, we are live this evening. You can contact us at 800-222-5222. Be happy to take your questions on either the topic that I throw out there or something that's just on your mind or needing some help. We certainly also take calls from veterans' families. I do spend a lot of time talking with spouses and parents of veterans who might just have been too frustrated with the process themselves, the veteran themselves, and reach out to some of their family members to kind of help lead the way to get them the help that they need. So more than happy to take your calls from spouses and family members of veterans who are trying to get through this process of dealing with the VA. One of the biggest questions that I get on a regular basis is, why does it take so long? Why is it so difficult to get things through the VA? And I often say that I wish I did not have this job because I wish it was not necessary. It certainly should not be necessary to hire an attorney to get your case through the VA or the Board of Veterans Appeals or the Court of Appeals for Veterans Claims. But certainly our phone rings off the hook of people who are looking to have that type of representation with a firm like ours that's been doing it for like about 25 years. So with that in mind, one of the first things I'd love to talk about, and again, our number here is 800-222-5222. You're welcome to give us a call. You can also submit your questions via social media. If you search on Facebook, Twitter, Instagram, or YouTube, search Veterans Law, and you will find us. Veterans Law Group is probably the easiest, and you will find us on all of those platforms. Feel free to submit your question there. One of the things that's kind of a hot topic right now in the veteran community was a new Senate bill that was passed last week called the Promise to Address Comprehensive Toxic, or also called the PACT Act. And that was overwhelmingly passed, one of the very few things that we see coming through that are in a bipartisan way, and very heavily bipartisan way. And that's kind of one of those things that when it comes down to veterans and their families, at least from a political standpoint, both sides or all sides of the aisle are typically wanting to help veterans. Sometimes there's a difference of opinion of how to go about that. But this PACT Act in particular, if it goes through, it is expected to be passed by the House and expected to be signed by the President probably within the next month or so. And it's probably going to be one of the biggest impactful changes to the substantive part of the VA benefits. So I say that very specifically because there was a bill that was passed that was implemented and executed in 2019. It was passed prior to that, called the Appeals Modernization Act, and that was a pretty big change in the process and procedures of how you go about appealing or filing claims with the VA. But this is getting into probably one of the biggest changes substantively to the benefits that that veterans will open up to. Some of it is medical support, new VA clinics that they're going to open, that kind of thing. But probably the biggest thing that I see, at least from our perspective of helping veterans get through the VA process, is it's currently in the way that it is formed right now. Of course, it's not final yet because it hasn't been fully signed and passed by the House. But right now, they're looking at adding about 23 respiratory illnesses and cancers that will be presumptively related to burn pits. So for those of you who are unfamiliar, burn pits, a lot of people who served over in the Middle East, there were pits that were on fire that put toxic chemicals into the air. And there's a whole slew of conditions in which there's been arguments that have made for years that they are caused by this, things that are respiratory cancer related, some gastro types of problems that are related to that. And I've called burn pits for years the next Agent Orange from a VA perspective. So essentially what happened with Agent Orange is years ago when the VA finally and the military finally fessed up to the fact that people who served in Vietnam and other places, which I'll get to that because there's going to be some benefits to that. But the simplest form is saying people who served in Vietnam during a certain period of time, put boots on the ground. If they later in life, at any point in time in life, developed a certain type of condition, such as Parkinson's is one of them, there's a whole list of them, that the VA will just presume that that condition is related to their Agent Orange. So if they had exposure, they get one of these conditions, you don't have to go through the process of proving what we call a nexus, that there's a link between the two. So you don't need a medical opinion that says that. There's a presumptive of that. So I've looked at burn pits for a while as eventually becoming one of those, and it's definitely more and more in this bill passes. If it passes, presuming that it passes, is going to add quite a few of those respiratory illnesses and cancers that's related to the smoke from the burn pits, the particular toxic fumes that were ingested and inhaled by our military community when they were over there. There'll be disability benefits in addition to some additional medical care that we'll see through that. So that is some great news, much needed to a lot of people that I've worked with over the years. The other thing it currently shows is it does increase a few things to that link to Agent Orange that we talked about, adds a few things including hypertension, which is one that I know a lot of people have wanted to see for a very long time, that is presumptively related to Agent Orange. And then some other things are also that's pretty big is it's going to open up, instead of just limiting those Agent Orange exposure to specifically related to Vietnam, there are some exceptions to that. If you were in certain areas in Thailand during certain times, it was just kind of hard to prove. We've worked a number of those cases, have definitely won a couple of those cases, but it's going to open up those areas to have a certain presumption of exposure to Agent Orange, like it has in Vietnam. So those countries are going to include Thailand, Laos, Cambodia, Guam. During the Vietnam War era, they would be kind of covered under the Agent Orange presumptives that people have seen for years for Vietnam. So it's quite a huge change. And generally what we see when these happen, when a large change happens, is there is a large influx of claims that are filed, and I would prepare anybody who fits in these categories. If you're listening to this and you fit within one of these categories, and it's going to open you up to be able to be available to file for some of these claims, I would love to talk to you, or a family member, or even a spouse, a widow or a widower of somebody who served in that time. Because there is kind of one of those things that there's a concept out there that they called, and if you're one of those people, I want to give you the number real quick to call, 800-222-5222. But I would expect that these are probably going to be covered under what they call a Nehmer which is just a case name, that if you ever filed for one of these and fit within these categories, then your case may be granted back to the date that you originally filed a claim. So if it was me and I was advising you and you fit within one of these categories, I would put your claim in sooner rather than later, even though the bill hasn't passed yet. It may get denied, but again, you have put in that claim. If you never never put in a claim for it, then your claim will only go back to the date that you actually file it. So if that's 2 years from now, 3 years from now, whenever they actually implement this. So it's a pretty big deal that is going to affect many, many veterans. I think the last statistic I saw, I think was on Military Times, they expect it to affect as many as 1 in every 5 veterans living in America today could directly be benefited from this new legislation. Now, obviously, somebody who is concerned about costs related to this, I will touch on that a little bit. I think they're expecting this bill to cost about $200 billion over the next decade. I tend to be pretty fiscally conservative when it comes to my perspective on the government, but my limitation on that is generally making sure our veterans are taken care of. Especially those, when I look at like Agent Orange exposure or burn pits, it's not something that you as a veteran signed up for, to be exposed to those kind of things, specifically Agent Orange. And in a lot of cases, people were exposed to it after being drafted, so they didn't even sign up for the military. So I think that it's our responsibility as Americans to make sure that those who put their life on the line for us are taken care of, specifically related to those things that they were affected by their time in service. So I'm, personally happy about a lot of the stuff that I see in there. It's certainly not a perfect bill. No bill ever is. But it definitely has huge strides, and I'm pretty impressed with the amount of bipartisanship that came through. The bill came through at let's see if I can find that real quick. It was passed 86-12 in the Senate, something that is, again, rarely heard of these days. So something that's going to come up. If you fit within this category and would love to talk about your claim, feel free to give us a call. We're going to take a break here in a second. You can reach us at 800-222-5222. This is Amanda Manier with the Veterans Voice. We will be right back in a few minutes. Welcome back. This is Amanda Manier with the Veterans Voice. I am your host here this evening. We are talking about all things related to the veteran community. Specifically this evening, we launched the first segment talking about the new PACT Act that has recently passed the Senate and will go before the House hopefully soon. I know that there's an expectation that it will see the House within the next month or so. Of course, it's politics, so we'll see what happens. But it does make some pretty monumental changes to what benefits specifically those who are exposed to toxic chemicals in the fires that were burning over in the Middle East, referred to commonly as burn pits. It also opens up a few additional presumptive conditions related to Agent Orange, and probably what I feel like is almost as huge as the burn pits is that veterans who served in Thailand, Laos, Cambodia, and Guam will be covered in the same way as for Agent Orange presumptives as Vietnam is. So right now, if you had served in one of those, you had to show you were on certain bases, that you were around the perimeter. It got a little complicated. We've won quite a few of those cases, but they're a lot more complicated and take some more time to fight for and get the benefits for if you fit within that than if you were a boots on the ground in Vietnam. So those are some of the things we're seeing. There's also, it's not in a final bill yet, obviously, because the Senate has passed their bill, but it's still got to go before the House. And they're looking at some of the phasing of rolling this out, like certain things that wouldn't go into effect until October of 2026, some things in October of 2023. I think that there could potentially be some court challenges on those types of things if the VA is acknowledging that there's a presumptive, but then it's saying, yeah, but we're not going to benefit you until 2026. I think we're going to have some issues with that in a legal battle. But we'll see what happens. Never a dull moment in the veteran community, that is for sure. We are live this evening, and I'm open for discussion with you guys about what you all are thinking, veteran, family member, or even a widow or widower of a Vietnam veteran or somebody who served and who unfortunately passed on due to some of these toxic chemicals. There will likely be some benefits in there that will affect you as well. So you can reach us at 800-222-5222. I understand we have Lieutenant Colonel Martin in Mission Viejo on with us. Welcome back. Thank you for joining us.
Hi, it's a pleasure to speak to you again. And again, I'll reiterate, you're the smartest person I've known in 20, 30 years about the Veterans Administration, and especially the legal side. So
Well,
thank
thank
you
you.
on that. And I'll get right to my point, and it was piggybacked off your burn pit and the earlier effective dates. So in this situation, filed in 2003 after coming back from Afghanistan, and they did have burn pits and a lot of other stuff that were burned in those pits. And then I had denied claims. However, today I'm now 100% 10 years, more than 10 years. So the question is, on the earlier effective dates, to be a Nehmer for some of these conditions that they have granted me, but only to 2011, not all the way back to 2003. Would I be able to make the claims for some of these other combat and burn pit related claims that were denied and or awarded instead of in 2003? They were awarded in 2011. And so that was my question about the earlier effective dates under burn pit and as a Nehmer.
Yeah, two things is one, the answer is, can you file claims for those? You can always file claims. It's just whether or not it's going to ultimately benefit you. If you're already getting 100% and you're maxed out on any sort of special monthly compensation, then you're not going to necessarily get a financial benefit for it. However, and you're past the 10 years. But the thing I want for anybody who's listening here is, well, first, if any of those you previously claimed for that would get you an earlier effective date for a higher percentage, then obviously it's worth applying for. If you're not within, somebody who's listening, not within those 10 years, if there's, I always tell a veteran, if there is something that, even though it's not going to get you any sort of financial compensation, if there's something that you could potentially die from or pass on from or be the cause of your death, I would go ahead and file it for it. You have that 10-year thing, which I'm only hesitating to say that because you probably qualify because of that anyway, but it ends up being benefits for spouses and children and that kind of thing. So there's that aspect of it. Just kind of comes into weighing, like, how much headache do you want to put up with for the VA to maybe not get any sort of benefit. But the answer to if you can file a claim is always yes. And to kind of expand a little bit more on what that Nehmer means, just to give an example. So if somebody had filed for hypertension related to Agent Orange 15 years ago or 5 years ago, and this legislation goes through, that Nehmer case basically says, if you previously filed for something that later the VA decided to grant as a presumptive to Agent Orange, you should get it granted all the way back to that day that you previously filed it, even though it was not a presumptive at that time. When legislation like this changes, it isn't an automatic that, oh, Nehmer is going to apply. There is questions that is Nehmer going to apply, and then the legal industry generally will push it a little bit, and they ultimately granted that with regards to the number of things that they added to Agent Orange previously. And there's some nuances with the burn pits, but it's definitely something to consider. And I always want to bring it again to the attention of somebody who is a widow or widower of a Vietnam veteran or a Afghanistan veteran who was exposed to burn pits, because it opens up their ability, even though the veteran has passed on, opens up their ability to file for some benefits that maybe their spouse wasn't able to get. Does that answer all your questions?
It does. The claims that were denied, like throat condition, heart and chest pain, gastrointestinal, and they did grant for skin conditions and the eyes, but again, they were years later. I was wondering if they did qualify as Nehmer, and also the ones that I just said that denied, if it would be worth it to chase that down and at least get the ball rolling, so if this legislation did pass, I would be in the window.
I would say yes. It's certainly not going to hurt anything to do that. And those people who are going to have pending claims are going to be the ones that are going to be seen first. So I don't have any problem with saying go ahead and file that stuff. And again, with your kind of experience of working in that, it's not going to be that big of a deal as long as you're willing to put up with the examinations.
Oh yeah, I know this place like the back of my hand.
Yeah,
I can teach them a few things.
I'm sure.
Then the susceptibility to COVID on this is another area that I've been thinking about, because a lot of my fellow veterans and active duty Army and reservists now, many of them have talked about the impacts of COVID. But I'll close with one quick comment, and then I'll call you again, say, in the future. My mother was married to, my father, a twice Vietnam vet, Navy, blue water, exposed to Agent Orange. He died without a claim. We posthumously filed for the dependency indemnity compensation for my mother without any sort of history. Some love letters basically did it, that she had APOAE from the ship in Vietnam, and she ended up getting the $12.84 a month all the way through when she died. And that was a real neat thing, because my dad's his pension was not as adequate or as much as the $12.84 tax-free from my mom. So anyway, I just wanted to share with you, and I really enjoy, and I look forward to the rest of the show and next week, and say hello to your staff. Star, we enjoy talking about your staff. Thank you.
Thank you. Appreciate it. Thank you for joining us, Lieutenant Colonel Martin. And I want to just kind of reiterate one of the things that he did say about that, and that's why I keep bringing up the, widows or widowers who of these veterans who maybe have gone on, is that if a veteran passes away from something that is service connected, their spouse is entitled to some benefits, even if the veteran never filed the claim. So all of these things kind of open up being able to look back and say, okay, did they have hypertension? Did they have one of these cancers? And it can become a benefit to a spouse even after they have passed on. So I've seen that many times to be something that is very helpful. And it's generally relatively, as quote unquote easy as something can be with the VA. It's not a difficult thing. It's not something that often gets denied unless there's too many question marks. And I say that in the sense of we work in appeals all the time. And so when somebody comes to us, they're unhappy with their decision. They've been denied or they've been underrated if they're seeking a percentage for disability compensation. And we just don't see that many DIC cases that come to us that are looking to appeal and that because they've been denied. So it seems to be something that the VA, might get it right a little more often than not. If you listen to this show, you probably hear me a few times say that I try to curb my cynicism as much as possible when it comes to dealing with the VA, because I know because we work in appeals, people are seeking our help, and they're upset enough that they're seeking an attorney's help because they're frustrated with the VA, which means I see all the cases that the VA either didn't get it right, or at least the veteran feels like they didn't get it right. So for those of you out there who have filed their claim, who are happy with what they received, who it wasn't too much of a headache, God bless you. And I'm glad that there are situations out there that I know there has to be situations out there that happen like that. It's just that when I see them, they're cases that are denied. And that's part of, working in the legal field in this, is that we're definitely working on the harder cases. If it's an easy case of the veteran had boots on the ground in Vietnam, that's fully acknowledged by the VA, they have Parkinson's, and then you're only arguing about a percentage. So those cases are certainly not that hard. After we get back, excuse me, after we get back from the break here, I do want to go into a little bit about appealing decisions. How do you make a decision, a judgment call as to where to appeal it, how to appeal it, those types of things. And again, we are live here this evening, so I'd love to take your calls. If you've got another topic that you want to talk about, that's just the one that I have on deck. Our number here is 800-222-5222. And again, you can always submit a question on all of our social media, Facebook, Twitter, Instagram, or YouTube. Just search Veterans Law Group and you will find us. Again, this is Amanda here with the Veterans Voice. We'll be right back after the break. Okay. Good evening. Welcome back. This is Amanda here with the Veterans Voice. We are talking about things that are affecting veterans. We're here every Tuesday night from 7 to 8 o'clock on 790 KABC, talking with you, with veterans or family members about changes in the VA disability compensation. That's where my expertise is, but also opening up to just kind of some things that are happening within the veteran community. Right now, under disability compensation, there is a current Senate bill that was passed. It is expected to pass the House, and then signed by the president probably within the next month or so, that will bring about quite a few significant changes in veterans who were exposed to burn pits, veterans exposed to Agent Orange, veterans who during the Vietnam era were in Thailand, Laos, Cambodia, Guam. So we were talking pretty much in detail prior to this. And if you're welcome to join us, we are live this evening. You can join us at 800-222-5222 to be a part of the conversation. Or if you just have a question about your disability claim or a family member's, feel free to reach out to us. I understand that we have Daryl. Is it in Standon?
Yes, this is Daryl.
Hi, Daryl. Welcome to the call. How can I help you?
Okay. Basically, I just wanted to make a little comment here.
Sure.
I called in a couple of times before and got some good answers from you. But the thing I wanted to mention that I worked with Lieutenant Colonel Martin also and heard him on today, and just want to let you know that the things he helped veterans with. I work out of the VA hospital as a volunteer, the Veterans Voice, and a lot of things that I learned to help people came from Colonel Martin, and he's a very knowledgeable person, and he'll take you to the right direction. And the thing I want to mention too is that how much he talked about you and how well you handle the veterans and things like that. And then coming from him, that makes you sound like you're even better than I thought.
Well, thank you. We worked pretty hard at it.
Oh, yeah, definitely. And like I say, too, you've helped me. I've called in a few times before and got some good answers from you, in which I'm able to share with the veterans I come in contact with all the time. So just wanted to tell you I knew Colonel Martin and appreciate you and the things that you're doing. Also, Colonel Martin, appreciate all he's done to help us, too. So just wanted to throw that out there.
Thank you so much. I appreciate it. It's always nice to hear that what we're doing is spending our Tuesday evenings talking to a lot of people out there. It's nice to know that it's resonating and helping people. That's the entire purpose of this show, so we appreciate it. Along the lines of... Thank you, Daryl. Along the lines of helping people out, I know there's a couple of frustrations that I know that our office deals with. I was just talking with some of my team members on Tuesdays throughout the day. I meet one-on-one with most Tuesdays and Thursdays with everybody in my office, paralegals answering some client questions, but also just kind of working through how they can, coaching them of how they can be better representatives and better at, advocating on behalf of our clients. And also, for veterans and their families of walking through this process, I wish that I could say that it was getting easier. It's not. It's getting more complicated. It used to be that you could fill out a claim on a napkin, or you could call the VA and say, hey, I think that I might have a back injury related to my service. And that would start the claims process. And nowadays, it's become so frustrating that you have to make sure you're filling things out on the proper form. And sometimes you don't even know what the proper form is. And we get stuck in that at times as well. So just to give an example, you now have basically three different forms. And this is the form itself, you can also do it online as well. But the first choice to make is if you've ever filed a claim for that condition before and were previously denied. If you were flat out denied, then you need to use what's called a supplemental claim form. But if you're filing for a request for increase of that same condition, it's a different form that you have to use. And if you file the wrong form, the VA will often, you'll get a letter from them, and it depends on you. Some of them are more informative letters, but some are not. You'll get a letter that comes back and just says, you filed a claim for this condition, you need to file it on the proper form, and they don't necessarily go into explain to you what type of form that it is. And then when you get into the appeals, which I want to dig into a little bit if we have some time, but it definitely is getting more complex from a procedural standpoint. And when you break it down of dealing with what do you have to prove to the VA in order to get your claim filed or in order to get your compensation, it's really not that complex. You have an in-service injury, you have a current injury or disability, and your current disability is related to that injury in service. There's three elements that you have to prove. So when it comes to getting a decision, if you were denied, it figures out, okay, which one of those elements is missing and how do I close that gap? How do I fix that? The other aspect of it is if you're looking at the proper effective date of when that payment was supposed to kick in, or the percentage that you get for each individual disabilities. So for those of you who are kind of new to this, each thing that you file for is separately rated. So it's first determined whether or not it's service connected. And if it is service connected, then the VA is going to assign a particular percentage rating to that particular condition. And that is based upon statute. So the statute says if you have these symptoms related to the injury, you have 10%. If you have these symptoms, you have 20. So it comes into it should be from a conceptual perspective relatively easy. You go to an examination, they note your symptoms, they decide that it's service connected, match up those symptoms, give you a percentage, and then the VA will take each one of those individual disability percentages. So if you have 10% for tinnitus and 20% for back injury and 50% for PTSD, that doesn't then become 80%, 50 plus 20 plus 10. They do what's called, what I call VA math, which means they take that and they calculate it. There's a chart that they utilize to calculate it. Many websites, including our own at veteranslaw.com, we do have a benefits calculator. You can plug in your different percentages. It'll tell you what your overall percentage would be. And then that overall percentage is what amount you get paid on a month-to-month basis. So it's always going to be on the 10. So 10, 20, 30, 40, 50. You get paid based upon that. And then a certain amount in addition for your benefits or for your dependents if you file for those dependents. So again, conceptually, it doesn't sound that complicated. So where does it become complicated? It becomes complicated because often, one, dealing with a bureaucracy that has a lot of red tape and a lot of frustration because stuff gets lost, things get misfiled. I should share with you that we have on our wall in our conference room what we call the VA shame board. One is a thank you board, multiple bulletin boards that are thank you cards and pictures of people who we've helped over the years. And that's wonderful. The other side is what kind of lightens our sense of humor in the office, because dealing with the VA is relatively difficult and frustrating on a day-to-day basis. I often tell people I have a permanent bruise on my forehead from dealing with the VA every day. And just because it can be like that, dealing with a bureaucracy every day and the paperwork. But then when you then add that they've complicated it more from a procedural standpoint, you have to fill out the right form. You have to do it at a particular period of time. And, if you file a supplemental claim, you have to have new evidence. It just adds to the complication of it. So the biggest piece of advice that I generally give any veteran I speak to about anybody who is getting out of the military or they're getting ready to file a claim sometimes many years later, there's no deadline on when you can file a claim for the VA. We have veterans to this day filing claims for Agent Orange PTSD from Vietnam So there's no limit on that. But my biggest piece of advice that I generally give is just don't do it alone. Don't walk alone in this process. There are nobody in the entire country or entire world, it's a statute that says, can charge a veteran for filing an initial claim with the VA. So because of that, most attorneys or for-profit companies work in the appeals department only, and we work on commission only. But outside of that, you can go to a veteran service organization who is typically funded a lot of times by federal money. So DAV, VFW, local counties, Los Angeles County certainly has one. I think Daryl was just mentioning that he volunteered to help people file claims. You can go work with them to file a claim, but I would highly recommend that you not do it yourself. Then once you get a decision, hopefully the VA will give you what you need. But if not, then you have options at that point. Many veteran service officers have been doing this for a lot of years. Some of them have worked in appeals, some of them have not. It just depends on who you're working with. And once you get into the appeals, that's where you can start seeking representation and help from an accredited agent or accredited attorney, or what they call a claims agent. So when we get back, I want to touch a little bit more on strategy of when you file, what you want to file. We'll be right back after this break. This is Amanda Vanier with the Veterans Voice here on 790 KABC. The Veterans Voice. We have been discussing new legislation affecting VA disability claims, and then also just a little bit of experience that I have as far as things getting a little bit more complicated with the VA and working with the VA over the years. One of the things that I wanted to maybe break down a little bit for you, we are live this evening. You can reach us here at 800-222-5222 if you've got a question or a comment about anything that we are discussing this evening, or you have a question about your claim. I'd be happy to take your call live and address those. But one thing I wanted to dig into in our last segment here is, how do you kind of break down what the strategy is when you get a decision from the VA and you're thinking that you want to challenge it, and there's 3 different ways to challenge it, and how there's really actually 6 different ways to challenge it, but 5 different ways to challenge it. And how do you determine which one to go with, and what are the benefits to each lane, as they call it, with the VA? So in making just a real quick, laying the foundation of what those different options are, you have a rating decision, you have a 1 year to decide to challenge that decision. So maybe you were denied PTSD, maybe you were underrated, you think you should have a higher rating for maybe a back claim. You can do what is called a supplemental claim. That means you want the VA to consider new evidence. So maybe you've got a new medical opinion, or you have some private medical records that weren't previously submitted, or under maybe a sleep apnea denial, you end up getting a statement from your, say, previous spouse who knew you at the time that you came back from being overseas, and you started developing snoring habits or difficulty breathing, and you have a statement from her or him, or a buddy statement. So anything that would be considered new evidence, something that is considered new and relevant to the claim, that generally you'll want to put into a supplemental claim. If you have new evidence, you can also take that up to the board, and I want to get to that, of why you would choose going to that route. But if all you really do is have basic new medical evidence or lay evidence, you would want to go supplemental claim. You also have the option to do a higher level review, and that means that somebody who with a little bit more experience is going to review the same evidence that was previously submitted. So under that circumstance, you can't file any new evidence that would be considered by that person. So the only time that option is really beneficial is if it's pretty straightforward that there was an error, or it's right on the borderline if somebody just kind of made a judgment call and said, not service connected or service connected, or it's a 30 instead of a 50. Or it's what we look at as a misapplication of the law. They apply the wrong effective date or something like that. The other way under higher level review is maybe the VA didn't even schedule you for an exam. So if you had for example, like a sleep apnea claim or a non-combat stressor claim, and they couldn't verify your stressor, or there was nothing in your STRs to show that you had any sort of back injury or ankle injury or psychological condition or any stressors, as they call it. But there is an argument to show that there was enough in the record that they should have at least ordered an exam. Those we will generally throw into a higher level review, do an informal conference with the VA, which you do have the option to do. It's not mandatory. And all it is a telephone call with the VA, with whoever's making that decision, where you can point out to them and make an argument, but you can't give them any new evidence. So a lot of times we'll argue that because the VA, that decision review officer or the higher level reviewer, will issue what's called a duty to assist error, which they mean, you know what, the VA should have, based upon the record, at least ordered an exam. And that will kick it back over to kind of the original claims department to order an exam and to be re-adjudicated. And if you don't get the decision at that point, you can do a higher level review again, which normally you can't. But that's the limitation on when we go higher level review. And then the other option is to go straight up to the Board of Veterans Appeals. And so that typically takes longer. That's the one hesitation. These days, what we're seeing with supplemental claims, we usually are seeing those turned around within about 6 to 9 months, sometimes even a little shorter. Higher level reviews we're seeing as coming in typically within just a couple months. So those happen a lot faster. And then when you go to the board at this point, we're seeing 1 to 2 years before it ever gets seen. And that's our experience of dealing with hundreds of cases on a regular basis. You can go look at the board members, numbers or statistics of the VA if you'd like, but that's a little frustrating because I can argue and I can see how they skew their numbers. So that's just from my experience. When you go to the board, you then have 3 options at the board. So this is where it gets, again, more complex. In the past, prior to this 2019 law change, there was just one. If you wanted to appeal, it was one form. You went one direction. It was straight up the chain. You wouldn't have all these options. So there's benefits to that, but there's also a lot of frustration that comes in with that. So at the board, you have 3 different ways to do that. You can do what they call direct docket, which is just like a higher level review. It's just that you're at the board. And being at the board, the decision maker is an administrative law judge. They have its team of attorneys. You're kind of dealing more in the legal world at that point. People who are much more experienced. And then if you direct docket, or you want to submit new evidence, but you don't want a hearing. So that's the other option. And then the third option, or the fifth option, is you want a hearing. So a hearing is going to take longer to get scheduled, but there's some key reasons why a hearing is really important and can be important in your case. If you have very little evidence to show your in-service stressor, or your in-service injury, so for example, some of the cases that I've worked in, if it's a non-combat stressor, so something happened in a training accident, something happened on a naval ship, something happened to you where you had a particular stressor. This is where also MSTs come up, military sexual trauma cases. And it really is going to come down to you don't have any physical evidence to support what you're talking about or medical evidence, but you can give testimony under oath, and then it comes down to credibility. And that's the only place at this point you can really get that on the record, unless you just do a sworn statement. But in my experience, when you have something like that, your testimony is much more compelling in person to the judge. You become a live person to the judge. They're not just looking at a set of files and reviewing, medical records. You can kind of feel the judge out a little bit. Our whole team has gotten really experienced at doing that, for the most part, being able to understand whether we need to do an independent exam or whether we feel like the judge is on board and on our side. So there are times in which waiting longer is actually beneficial to your case, not the wait itself, but going before a judge at the board level and having a hearing. So those are just kind of some of the analysis that we look in. The other thing that makes it a little more complicated under new appeals is you can take each issue that you have into different lanes. So you could have your PTSD in a supplemental claim, your back condition in a higher level review, and then appeal your sleep apnea up to the board. So then it's a matter of managing where all your issues are and, you know, what's going to be seen first, what evidence do you need, and that can get complicated, but there's also some, you know, tactics and reasons for taking each issue to a different level. Maybe you don't have new evidence for the PTSD claim, but there should be enough in the record to grant it. You can't put that in supplemental claim because you have no new evidence. You got to either go to the board or higher level review. So those are just kind of things that before we went to break before, I was talking about how my biggest piece of advice when you're dealing with your VA disability claim is don't do it alone. And working with a VSO office or working with a claim agent or an attorney's office like ours, we've worked hundreds and thousands of these cases really to kind of help with strategy of what's the best way to get you the maximum benefit with the earliest effective date on the easiest route possible. And sometimes that doesn't come across as easy to explain, but our office definitely, paralegals are amazing. Many of them are veterans that have gone through this process themselves. All of them are either veterans or family members of veterans. So we would be happy to help you out. We are here every Tuesday night doing the Veterans Voice to ask your questions. But if during the week you want to reach out to my office, we're at Veterans Law Group, so veteranslaw.com, and you can reach us there. We will be back next Tuesday night here on the Veterans Voice. This is Amanda Manier on 790 K.